If anybody has anything to add, it will be really nice. So please feel free to add anything you feel that something which I missed.
Thank you for joining, sir.
सर किसके लिए सर? यमन के अच्छा हाँ सबके लिए बैठी.
ये करना ठीक है सर.
So good evening everyone. My topic of presentation is Haryana Job Reservation Law. Such laws have always been controversial because they are backed by a political motive. And the Haryana State Employment of Local Candidates Act 2020 was an election promise which was made in 2019 assembly elections by the Haryana Deputy CM Dushyant Chautala. And so the Haryana government has come up with this law because they feel that this will help secure employment opportunities for the youth in Haryana state, basically private sector. And also they feel that the urbanization and industrialization in the state has led to huge land acquisitions, which has significantly affected the industrial, which has significantly affected basically the it has significantly affected whatever possibilities or opportunities are there in the agriculture sector. So they feel that with this kind of new jobs created for you, it will help them to grow. Then reservation quota. What does this law provide? It says that 75% of the reservation has to be there for the local candidates in the private sector employment, and only for the jobs with the gross monthly salary of INR 30,000. Originally, this amount was 50,000, but there was a lot of oppositions from the industrial associations, so they have reduced this amount to 30,000. This law is not permanent in nature as of now. It has limited period applicability. It is only there for 10 years, the date of commencement of the Act, which is 15 January 2022. And so this law is prospective in nature. That means it will be applicable only for the new recruits. It will not affect the existing employees which are there on the payroll. This was a big concern for most of our clients which are based out of Gurgaon. Once this law was there, they have called us and they wanted to understand that once this come into the implementation, what will happen to the existing employees, which may or may not be fall under the category of local candidates. So this is not the first time that Haryana has come into, Haryana has come up with such kind of a law, which is based on domicile. There are other states, Andhra Pradesh is there, then Jharkhand is there, Maharashtra is there, and Madhya Pradesh. So Andhra Pradesh was the first one which introduced domicile-based reservation law for private as well as public sector in 2019. However, it's not smooth, as it is for Haryana, that there have been challenges. So the other states are equally facing such kind of problems in implementing of this kind of domicile-based law. What I've done, I have mentioned here the key dates, which is important from the perspective of the implementation of the law. March 2nd, 2021 was the date when this act was notified in Official Gazette of Haryana. Then November 6th, the Haryana government have come up with a notification where they have reduced the threshold limit of the gross monthly salary from INR 50,000 to INR 30,000. This is with respect to Section 3 of the Act, which requires compulsory registration. So Section 3 provides that all the employers have to compulsorily register all the details of the employees whose maximum gross monthly salary is INR 30,000. So, and then November 6th, they came up with another notification which provided for the date of commencement, which is January 15, 2022. Then December 24, 2021, the Haryana government issued another notification with respect to Section 4 of the Act, which provides that the government, the private employers have to employ employees in the salary bracket of 30,000 and below, they have to employ at least 75% of the local candidates. So earlier, this threshold limit was 50,000, and with the opposition coming from the industrial associations, they have reduced this to 30,000. Then January 10th, they notified the rules which basically provide for the registration, which is one of the mandatory requirements before they could come up, or they could, whatever requirements are there of the act, they could fulfill those requirements. So these rules were notified on January 10th. Then January 15th, the act's rules and all the notifications which we have discussed earlier, all of them came into effect. Then January 17th, once this law was notified, then it was implemented on January 15th. January 17th, the Haryana government came out with an office order which provided deemed exceptions for certain category of employers, which will be discussed in later slides. This is a relatively smaller act and with very few definitions given thereunder. So I have just mentioned the ones which will be relevant for this PowerPoint presentation. Local candidate. A local candidate is a person who is domiciled in Haryana. Domiciled person. The candidate who is a bona fide resident of Haryana State and who has a Parivar Pehchan Patra issued under the Haryana Parivar Pehchan Patra Act 2021. It's not that anybody who has a residence in Haryana will be qualified as a local candidate. There are specific requirements. A person has to be a domicile. Generally, the conditions for domicile is 15 years in most of the states, but the Haryana CM, they have reduced for the purpose of this private job reservation law, they have reduced the domicile requirement from 15 years to 5 years. And this Haryana Parivar Pehchan Patra, this is an ID which a family has to obtain, and this is specific to Haryana government only. Then comes the employee, any person employed by the employer on payment of salary, wages, or any other remuneration, but it does not include an apparatus. Then comes the authorized officer. So authorized officer is a government officer not below the rank of an SDO, subdivisional officer, or any other officer which the government may notify from time to time or designate from time to time. Designated officer, a government officer not below the rank of a deputy commissioner, or it could be any other designated official which the government may notify from time to time. Then appellate authority, he is a government officer not below the rank of a labor commissioner or any other officer which the government can notify from time to time. Designated portal. So Haryana government has come up with a specific designated portal for the registration purposes, and any notification, anything related to this particular Haryana Job Reservation Law is placed there. Even they have the FAQs, which gives a lot of ease to understand how this law has to be implemented or what are the basics of this law. So Section 3 of the Act provides for compulsory registration of the employers. So it is not that the employer has to register themselves and only create their login. They also, what is compulsory registration here is that they have to register the details of the employee who are irrespective of whatever domicile status they have, who are coming under the salary bracket of 30,000 and below. So they have to give the information of all those employees on this portal, designated portal they have to mention. And they also have to use a Haryana Udyam Memorandum ID number, which is also given specially by only to the Haryana entities. There is a specific act for that, and they have to register themselves within 3 months of coming into force of this act. So what the law provides that this is a big challenge which the entities, private employees may face going forward once the court, whatever decision the High Court will be discussing about that later, will be making. So any new recruit or any new employee which has to be hired by a private employer, they can do so only once they have registered the details of the existing employees coming under the salary bracket of 30,000. Once they have done that registration, only then they can hire. Otherwise, they will be, attracting the penalty under the Act. Then there is statistics given on the Haryana designated portal that till now 1,055 employers have registered themselves on the portal, and it is not only the employer who has to register, but it is also a local candidate who has to register if he wants to, or if he or her wants to avail the benefit of this act. So it's not that I go to an employer and tell him that I have this domicile certificate in place, I have this Haryana Parivar Pehchan Patra in place, and that I'll be eligible to get the benefits. I also have to be there so that the database from where the employers can select the preferred candidates. So that's the whole idea behind having this particular designated portal where the database is there for the local candidates. So this is a interface which is there on the designated portal, where one side, if you could see, it's mentioned local candidates, and the other side it's employers. So they have also provided for user manuals for both the local candidates as well as the employers, which provides the prerequisites, or which gives you how you have to, for the ease of registration purposes, they have given everything in the user manual. And then there is sign up login, sign up option and login option. And if you see, almost about 50,075 people have registered themselves. So it's a huge number. This portal came into effect only on 15 January. So there are a lot of people who actually want to be categorized as local candidates and they feel that they should be given this benefit or they should be given this opportunity. And if we see from the employer's perspective, it is only 1,055. Maybe they are just waiting for the verdict of Punjab and Haryana High Court to come and see how this law would fall into place. So this animation is there for Deepa ma'am. Once, if such kind of law comes in Delhi, then you will have to put cross on most of the resumes. Basically, with effect from January 15, 2020, every employer in the state of Haryana is required to reserve 75% of the jobs for and having gross monthly salary. So it's important. One of my clients have asked me this question, whether it's gross monthly salary or is it the basic pay, because it makes a huge difference. It's the CTC. Then there is a possibility that lesser number of people will come to purview of this act. So it's whatever the job post which have gross monthly salary bracket of not more than 30,000. So there a reservation has to be made by private employers of 75%. However, this condition is applicable in case of new recruits. So it is prospective, as we discussed, it's prospective in nature and not retrospective. So the employers where the employees are already in place, so they are not at threat. But however, whenever they have to choose the new recruits and the kind of database which would be created, it will be only for the employees which are registered themselves on the portal. So there could be a possibility that a lot of people who are, who have the potential but have not registered, so they could, employers could miss out on those employees, or they could miss out on the employees who are, who have that talent, analytical bent, but since they do not fall into this category, so there is a problem where employers feel that this law should not come into place. Then local candidates can be from any district of Haryana. It is not necessary that नहीं notification बंद कर So local candidates from any district of Haryana, however, the employee has the discretion to restrict that from a particular district, he will not employ more than 10% of the total number of local candidates. So now when an employer has been obligated to reserve 75% of the jobs with a salary bracket of 30,000, They have also come up with an exemption provision under the Act and the rules, and how they have given the procedure that employers who feel that they are not able to get the requisite talent on the designated portal, then they can adopt for this route. And what they need to do, that they have to file an application on the designated portal with the designated officer, and they have to furnish their the reasonable grounds, and they have to justify that why do they feel that there are no appropriate local candidates for their kind of requirement. And they also have to, they also have to justify somewhere or the other that they have made the attempt to look for the appropriate candidate from the local candidates, but they were not able to find out, because the designated officer, once he receive the application, he will have an option to make an inquiry, or he can seek an assistance from the authorized officer, that is an SDO. So Deputy Commissioner has the option to, even seek assistance from the SDO, that in conducting the inquiry and also verifying the grounds which is mentioned in the application. And then accordingly, he will have to pass the whatever order, whatever he feels, he'll have to pass the order within 15 days. So it's a time specified which is mentioned, but it's not a deemed exception, deemed rejection or anything. So they have given a timeline in the Act itself that within 15 days, they're bound to revert. And in case if it is not complied with, then at least the every person can, take this reaction or request them. Then they'll also have to upload the order, whatever decision they take, they'll have to upload that on the designated portal. And so what are options once the application has come and he has held the inquiry? So what are options a designated officer has? So the options which he has, he can either accept the application, he can reject the application, and the most critical one is that he can direct the employer to train the local candidates to achieve the desired skill, qualification, or expertise. So, it might be a big challenge if a designated officer tell the employer that, see, generally we go to hire employees only when we are in dearth of, we require them urgently to do our work. And there, if we are not able to find out first, we have a limited pool from where we can select them. After that, if we are not able to get that kind of a local candidate on the portal, then, directing an employer to train the local candidates as per your need, it could be a big challenge for the private employers, because definitely it will, involve some kind of training, some kind of amount, and additional cost factor. Then any exemption, once an exemption has been made, they have accepted the claim. Once an exemption has been made, then the employer will have 1 year period from the date of the exemption to fill up that vacancy. In case they are not able to hire any suitable person who is not a local candidate within 1 year, then the position would be the same, that that particular vacancy will again be turned as a fresh vacancy, and he can go in for an exemption only once he have given the training to the whatever kind of employees or whatever kind of local candidates are there. So at least they'll have to give the training first. They'll have to showcase that even after giving the training, or they are not able to find out anybody, then only second time exemption would be allowed to them.
So, Gunjan, how does the designated officer make sure that you've already evaluated all local candidates?
So, ma'am, there is a option that he can conduct inquiry, and then he will ask the authorized officer. See, it's going to be a practical thing, that how they will have the manforce to ensure that whatever claim I have filed there, or whatever I have mentioned there. So every time they are passing an order, they'll have to give us an opportunity of being heard. He will call the requisite person from the company, and then they will be, whatever information they feel is required to, where we can justify our claim.
Otherwise, in Bangladesh, etc., Indonesia, you have to release an advertisement before, for instance, you take an expat. So this is states. So is there something like that you release an ad? Or अगर उससे नहीं fill हुआ, then we can go
so
not.
Ads would come into place where I'm looking for somebody in general. But here, what is happening when I'm looking for a suitable candidate out of the local candidates? So I have a pool there on the designated portal from where I'll have to choose. So maybe I can just showcase that I have, called out the people whom I feel would, little bit also they fulfill my criteria. Then I'll call it to them. So some kind of a justification I need to, some kind of a documentation or something have to be proved to them that yes, yeah, that they were not able to satisfy that kind of a test. And even in case of training also, I think something would have to be implemented to at least showcase that we try to call those people. There was some training for initial 1 or 2 months, like we do probation, and still they were not able to, justify for like whatever requirements I have. Because even I cannot wait for a very long time. That's why I want to hire an employee because my work is getting affected. And we'll get to know only once, this will get implemented, because in other states also, there has been a very slow implementation.
It's state and the IT.
Yes, sir. It's only with respect to Haryana. Huh?
Because of this law, companies have started moving their bases to Noida. This act is state.
Yeah, but then they will find it difficult. The ease of doing business will get affected.
This is state to harm. This is.
नहीं ये जो सुप्रीम कोर्ट को I'll discuss that over here. So there are few states which have come up. Basically, this is all political agenda which they want to, they make it as an election promise, and then they try and bring out that kind of policy. They say it's sons of soil policy, that they're trying to protect and provide employment to the children of the state. But then it's all politically moved. Yeah. So after this act was, it was implemented on January 15, 2022. So the Haryana government came out with an office order just 2 days later, and they came up with the deemed exemptions in case of these few selected employers. The first one talks about the new startups and new ITS entities, that if they will get exemption from applicability of this act for a period of 2 years from the commencement of the business. However, there is another condition to this, that this new ITS and the new startup has to commence business within 2 years from the commencement of this act. Meaning thereby that if there is a startup or there is a new entity, ITS entity, which is established after 3 years or 2 years of this act coming into effect, then they will not be able to claim this deemed exemption. Then comes the short-term employments of less than 45 days, vacancies under any employer primarily engaged in agriculture activities, but this does not include agriculture allied activities where there is a factory, and any you using any manufacturing unit or something like that. So those kind of entities or those kind of employees will not be covered here. Vacancies in residential homes for domestic work or services. Vacancies. So this E part is very relevant for us. Vacancies being filled up through promotion or transfer or by absorption of surplus staff of any unit of the same employer in Haryana. So in my client, with my client ICOR, they checked with me that there is a possibility that I have a vacancy, and then rather than hiring from somebody from a local candidate, I would prefer to intermingle and fill up that vacancy from that place, because till the time they have not completed with the registration on the designated portal, they will not be hire anybody from outside. So what they will do, they can use benefit of this E portion, and then that's how they can fill up the vacancies. So for our existing clients, E could be relevant. Any class, post, skill, and category of employment notified in the official gazette. So nothing has been notified till now. Government may from time to time, where they feel that there cannot be local candidates or there are no local candidates with that kind of expertise, they can say that these class or post or skill or category of employment will be covered under deemed exemptions. So already so many compliances are there under various laws, and this law would bring in additional compliances for the employers, because they will have to file the quarterly reports, which has to be filed once the quarter is over by 20th of the next month. And in the quarterly report, they have to give the information that how many job vacancies were there, how many local candidates they have hired, and such other things. Once they have uploaded this quarterly report, so it's not just like a normal filing that we have filed the quarterly report and no further action would be taken on that. The authorized officer is required or obligated to, once we have filed this quarterly report, they have to see this and they can call in for any further information and they have to pass an order and they have to place their order on the designated portal. Every time, so one thing which I really liked about this act, which is there in the favor of the employers, that every time an order is passed or any kind of notice is issued and anything is there, they're mandated to call them and give them an opportunity of review, so that at least they can present their case. It's not something like I fight a quarterly return. They feel that there are some issues into it, and they can just unilaterally pass an order against me. So that is there. Maintenance of records. Every employer has to maintain the records in electronic form about the local candidates, about how many employees they have, how many employees are there under the gross monthly salary of below 30,000, and what are the post-wise details of those employees, what kind of a training I have imparted, whether I have got any exemption during the last quarter. So these kind of information needs to be maintained in the electronic form. Additionally, under this act. Also, there are other rights under the law, as we have seen and as I have discussed that at various places, the act provides for an opportunity of being heard to be given to the employer and even in some cases to the local candidate. There are these two other additional rights which is given to them. In case of employer, he has a right to appeal. So if he feels that any order which has been passed by the designated officer or by the authorized officer, then within 60 days he can prefer an appeal to the appellate authority. So appellate authority here is Labour Commission. Then appellate authority, after receipt of the appeal, it will have to give the opportunity of being heard to both the parties and it will have to dispose of the appeal as soon as possible. Most of the orders and whatever needs to be done under the act, whatever requirement has to be complied, there is a timeline which is mentioned, but for disposing of the appeal, nothing is mentioned. It just says that they have to do it as soon as possible. In case of a local candidate, he has a right to file complaint. So when we say he has a right to file complaint, he can file a complaint against the actions of the employer where he feels that he has violated the provisions of the act. And he can file this complaint online only on designated portal in Form 2. Once the authorized officer has received this complaint, he'll again have to give the opportunity of being heard to both the sides and dispose of the complaint within 30 days. So what we can see here is that the local candidate only has the right to file the complaint with the authorized officer. But if he feels aggrieved by the order of the authorized officer, he has not been given any right to file an appeal with the district officer or the appellate authority. It is only the employer who has been given that right, that he can go in appeal against the orders of the authorized officer or designated officer. So something you they should have given that kind of a right to feel that to the employer they have given, but to the employee only we can approach the lowest level of officer, that is the authorized officer. Not beyond that I cannot.
Sometimes you want to keep this also in control, no? Otherwise there is no end.
Yeah.
If you keep on filing complaint one after another, and this is also, you are saying local candidate, not even the employee. Like any person who is eligible, who is not given an opportunity and he can go and file a complaint.
Right.
So I think
because I think when it comes to employee, the other employees also they can go to the labor.
Because in law there are several times it is said that it is not that in every circumstance you have to give an opportunity of being heard. Otherwise things will never be come to an end.
Then the act also provides for penalties. The first one is
we can skip.
okay. Who would be liable for the offence under the act in case of a company? So there is something interesting I would like to share here. In case of a company, it is deemed that a company has done a default, then every director, manager, secretary, agent, or other officer or person concerned with the management he would also be automatically liable for it, unless and until he proves that it was not done with his consent or knowledge. In case of LLPs, it is mentioned otherwise that it is for the officer or it is for the authority to prove that the LLP and the partner and the designated partner was at fault, which is different from, like, generally there is a presumption that the person who is responsible for the management or affairs of the entity is deemed guilty until and unless he proves that.
But language to say that
They said LLP and the FD partner or designated partner where it is proved that the offence have been committed. So in that case, it has to be proved by the authority. Only in case of LLP, authority has to prove that they were at fault. Or in the other two, it is for the it is deemed that they are at fault. Maybe I can change it a little better to make it bring more clarity. Also, in the case of offence by the societies or trust, anybody who is in charge or responsible for the conduct of the business of the society, it will be deemed that they are at fault unless they prove that it was not committed, it was committed without their knowledge or consent or their negligence on their part. So there are different views and there are diverse views on this domicile-based resolution. So industry feels that it is an infringement of the constitutional right of the employees. There are time and again there have been different constitutional rights which have been which have come into picture.
Employers.
Listen, industry feels industry is against this law. So they feel it is like it is violative of yes. Oh, I'll change it later. Employers, yes.
Thank you.
No, you have told me that.
Thank you for the direction.
Yeah, thank you for the direction. So I'll change it to employers. So it is basically they feel that it is an infringement of the constitutional rights of the employers. It has been debated and it is a debatable topic. So I have not dwelled too much upon it. And then they feel that it is against the basic principle of selection of merit, which a private employer has, that he has the right to select the employees on merit, and the state should not impose them these kind of a database that you have to select the employees from this database only. It affects the productivity, industrial competitiveness, and post-recovery industries after COVID-19. And FICCI has said this, that it would spell disaster for private investments in the state and impede industrial development. So where we feel that more and more MNCs are coming into Gurgaon and industrial, we are looking at the jobs at international levels also. So here what we are doing, we are trying to narrow down the jobs only to the locals. So that's why industry feel that this is something which will affect the growth in that particular state in the long run. Whereas the Haryana government is of the view that what they're trying to do, they're trying to protect the livelihood of their people within the state only, and they feel that this will help to reduce the crime rate as they aim to reduce the unemployment issues by means of this law. And also they feel that they'll be less dependent on the migrant workers. So generally the employers feel that when people are coming from outside, they stick to the job better and there is less attrition in their places as compared to the locals. But both the parties have their own views, and that's how the debate is going on in the courts. So the legal battle so far, the industrial associations in Haryana, they have filed, they have challenged the constitutional validity of this law, and they have approached the Punjab and Haryana High Court. So when this matter was taken up, the Punjab and Haryana High Court said that the core issue here is even whether any state can restrict the employment even in the private sector on the basis of the domicile. Within few minutes of hearing the arguments, they granted the interim stay on the implementation of the act. So agreed by their decision, the Haryana government challenged this interim stay before the Supreme Court, and the Supreme Court said that the High Court in their order has not provided sufficient grounds for putting the law on hold, and they repeated this stay. Then Supreme Court further said that the High Court has to decide on these writ petitions within a period of 4 weeks, which has already expired, and they have to Supreme Court told the Haryana government not to take any coercive steps against the private employers who are not able to comply until this matter is resolved. So on March 17, 2022, these and also the Punjab and Haryana High Court, once this matter again came before them, they asked the Union of Law to give their viewpoint also on this particular issue. So they filed a short reply and they said that it's a state enactment and they do not have much to say on this. To which the court said this is very strange, that this is not something which will only be affecting the employees or affecting the people staying in Haryana, but it will have a long-term consequences on the pan-India people. So then Union of India again filed a reply, and after hearing the parties, the arguments got concluded on March 17, 2022, and High Court reserved its judgment, which is still awaited. And so we'll get to know the fate of this law only once the judgment is pronounced.
Right now, it's not in effect.
No, ma'am. This law is there, but the stay has been vacated, and people who want to register themselves, they can do it voluntarily. But the government cannot take any coercive action against them. So the moment this judgment is pronounced, and we'll get to know what
That
is
is why I said skip penalty. I will let you know.
I am really surprised that the center is not doing anything, because it's really unfair if Gurgaon is going to have all the promotional thing and you restrict that you want to take all the employees under 30,000 only for Gurgaon. It's very unfair.
no, it's 75% basically.
75%, but that's enough. It's like you want to
Yeah.
Earlier, Connaught Place was a hub, or say any of the metros, Maharashtra, Bombay is a hub. What about the other people? You want to give them the opportunities pan India?
So, ma'am, a lot of states are coming up, even for Punjab.
This can be,
And then what about now? Most companies are anyway taking employees from online. They don't even want a physical office. So how are you going to,
Implement this.
Catch here is that bracket of salary. What they have done, they have reduced.
30,000? I know.
So
And
under
under.
30,000 bracket, there would be
Salary
sorry,
and
class 4
clerks
employees,
and
class 4 employees.
clerks and-
Those